Today, Jim Griffin and I filed a petition based on newly discovered evidence with the South Carolina Court of Appeals to stay Alex Murdaugh's appeal while a hearing is held on a motion for a new trial. Concurrently, we've sent a request to the South Carolina U.S. Attorney to open a federal investigation into the violation of Alex Murdaugh's civil rights. The allegations in the petition filed today speak for themselves, but we believe they explain a number of peculiarities in the 6-week trial. We request that SWED stand down on initiating any investigation of these allegations since they are heavily invested in maintaining Alex's convictions. We suggest they wait for the Court of Appeals to rule and receive direction from the trial court. If the Court of Appeals remands the case for an evidentiary hearing, if the Court of Appeals remands the case for an evidentiary hearing, we would also request that those in the media and the public respect the privacy of those included in this filing. Jim and I want to thank those on our team who stand behind us and have worked tirelessly to ferret out the truth. Alex Murdaugh maintained and still maintains his innocence in the murder of Maggie and Paul and believes the truth will ultimately prevail.
The right to a jury trial is a fundamental principle of our justice system. Jurors must be free from outside influences and must decide the case solely on the evidence presented in the courtroom, subject to the rules of evidence, subject to the rules of the court, and, most importantly, subject to the crucible of cross-examination that's guaranteed by the Sixth Amendment to the Constitution, and that is the right to confront witnesses. When jurors receive private communications outside the confines of a public courtroom, the Sixth Amendment is violated and numerous other constitutional rights are violated. And that's not Jim Griffin on the law, that is the law of the land. And I want to quote from a decision from the South Carolina Court of Appeals, which is behind me, and states this: where there is a private communication of a court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict. What we had filed today, supported by sworn testimony of jurors, is that the clerk of court had improper private communications with the jurors, and the subject matter of those communications was the credibility of the defense that the Murdaugh legal defense team put up, and it was the believability of the defendant's own testimony. Now, there's been a lot of talked about whether Alex should have taken the stand. I can assure you, when we considered what factors and what we should and should not do and considered whether he should take the stand, we never considered the likelihood, as reported to us by the jurors, that the clerk of court would go in to the sanctity of the jury room before he testified and tell the jurors, don't be fooled by his testimony, watch out for his body language, and that is what the sworn testimony that we have filed in court today says. And if that is true, which we have every reason to believe that it is, and no reason to believe that it's not, there's no choice but the courts to grant a new trial.